All right, we'll go ahead and call the Marshall County Fiscal Court. It's going to be a special call meeting, September 28th, 2020, at 11:45. We'll have a public meeting here in about 15 minutes. The first item is going to be the tax rate. Let's go down and read this. The 2020 tax rates in order relating to the adoption of 2020 Marshall County tax rates, whereas the Kentucky State Revenue Cabinet has certified the Marshall County property assessments as real estate, $2,053,779,607, tangible property, $227,816,905, public service companies, real and personal, $123,204,723, motor vehicles, $285,652,186, watercraft, $36,320,989, aircraft, $30,500, watercraft, non-commercial, $3,746,680, inventory in transit, $96,996,509, other agricultural products, $28,984. Now, therefore, it is ordered by the Fiscal Court of Morris County, Kentucky, Section 1, in accordance with KRS 68-245 through 68-249, there is levied for the year 2020 the general ad valorem tax per $100 assessed valuation on all taxable property within the jurisdiction for the general fund, and such additional tax rates for each special district or other fund as indicated. So our business today is the tax rate. Do you want to go over what it was last year?
It was 9.4, and that is still our compensating rate for this year is 9.4.
So for the court, do we want to keep the tax rate for the general fund the same for this year?
I move we'll keep it the same, 9.4 for real estate, 9.4 for tangible.
Second.
All those in favor say aye. Aye. Any opposed? Motion carries. General fund, real estate 9.4, and tangible personal 9.4. Health district is 7.25 for both. Hospital district is 3.8 with 4.4 for tangible and personal. Library 9.4, 10.28 tangible and personal. Refuse district 8.7, 8.75 for tangible and personal. Extension district 1.745, 1.8488 tangible and personal. Soil conservation 0.575 for real estate. Gilbertsville Fire Department 7.5. East Marshall Fire District 9.4. Possum Trot Sharp Fire Districts 6.8. Draftonville Palma Fire Districts 10. And West Marshall Fire District 8. Fairdealing Olive Fire Department District 10, and South Marshall Fire District 9.5, and that's for both real estate and tangible. Section 2, in accordance with KRS 132-487, there is levied for the year 2020 the tax rate of 11.2 cents per $100 of the taxable value of motor vehicles, watercrafts registered in Marshall County. Section 3, in accordance with KRS 136-575, there is levied for the year 2020 the tax rate of 25 thousandths of 1% on bank deposits held by financial institutions within the County of Marshall. Section 4, this order shall be published in the Tribune Courier newspaper by the title and summary within 30 days following adoption. Section 5, this order becomes effective upon passage and publication. Order passed on this 28th day of September 2020. We'll move on to item 2, rural and municipal aid agreement. Just read this. Okay. You have any questions on the agreement?
Move we accept it.
Is there a second?
Second.
All those in favor say aye.
Aye.
Aye. Any opposed? Motion carries. And I will read the resolution. Fiscal Court of Marshall County, a resolution adopted and approving the execution of rural secondary program agreement between the Fiscal Court and the Commonwealth of Kentucky Transportation Cabinet, Department of Rural and Municipal Aid, and accepting all roads and streets referred to therein as being a part of the county road system. Be it resolved by the Fiscal Court that the Fiscal Court does hereby certify that all roads and streets referred to in said agreement are county roads as defined in KRS 178-0101B, and the Fiscal Court does hereby ratify and adopt all statements, representations, warranties, covenants, and agreements contained in said agreement, and does hereby accept said agreement, and by such acceptance agrees to all terms and conditions therein stated. And the county judge executive of the county is hereby authorized and directed to sign said agreement as set forth on behalf of the Fiscal Court of the Morris County, and the county clerk of Morris County is hereby authorized and directed to certify thereto. Motion
We
to
adopt
approve.
we adopt the resolution.
Is there a second? All those in favor say aye.
Aye.
Aye. Any opposed? Motion carries. Next item is appropriations transfer.
Okay, on your transfers, all of these represent amounts that have already been paid with bills. This is just for the quarter end, kind of wrap up as we do our DLG reports. You'll see a lot of movement into the capital projects out of the bonds and other investments or the DRA grant fund. And that's just, when we pay the bills, we pay them out of capital projects, but that's not where the money was budgeted, if that makes sense. So we have general fund bond money to 911 for 911 upfit. We've already done one transfer. This is just an additional one for bills that you all have already approved to pay. General fund investments to capital projects, about $12,510 for the Draftonville sewer expansion. We have general fund investment in bonds to capital projects, $74,9743 for the Jonathan Creek Water Project. DRA funds, the capital projects of $100,521.90 for the Southwest One Boulevard Project. Investments, which we had budgeted in the road fund, to the capital projects of $358,638.52 for the right-left turn lane at Southwest One. General fund investments to the capital projects of $488,396.12 for the Southwest One Sewer Project, and then our occupational tax investments to capital projects for the remainder of the multipurpose building bills that came through.
Move we accept the appropriation transfer.
Second.
Second.
All those in favor say aye. Aye. Any opposed? Motion carries. I went to some training last week, and it was actually some pretty good training. Zella Pearson, I don't know if y'all have ever heard of her, but she's very knowledgeable, been around for some time. When it comes to payment of the bills, apparently, this is very interesting. Back in the early 2000s, in McLaughlin County, the fiscal court was so divided that they literally pretty much tied on their votes, even paying the bills. So it became an issue, and Tommy Turner, I know some of y'all know Tommy Turner, he just recently, Judge Executive of Little County, just retired. He helped draft a bill that helped change this issue back in the early 2000s. And so today, or since then, KRS 69210, it's not an action item to pay the bills. Well, who knew? This is the first I'd heard of this. But it was pretty interesting to see, and if you go to 69-210, you pull that statute up, you'll see it's actually falls on the duties of the county attorney. So the county attorney, he or she shall oppose all unjust or illegally presented claims. So Tommy Turner, as a judge executive, once that bill passed and that became law, his language, and I looked at his language as far as how he conducted his fiscal court, and I'm just going to do the same when it comes to the bills or claims presented to the fiscal court. He asks, is there any reason to deny payment of the bills and claims? So starting today, that's what I'll ask. Is there any reason to deny payment of the bills and claims that have been presented to the court? If not, then basically you follow up with let the fiscal court clerk record that the bills, claims are to be paid. If there is a bill that is illegal or unjust, then there needs to be research on that bill or that claim. And if that were the case, and if there was a motion by any member of the court, voting members of the court, made and seconded and passed not to pay a bill for XYZ industries, then it would be let the fiscal court clerk record that the bills, claims other than XYZ industries are to be paid. And from there, then it is to be researched by the county attorney. So that was discussed and passed in the early 2000s so that the state says that the fiscal court shall pay the bills. And so that was the problem within McLaughlin County when they were deadlocked on pretty much everything. And to some degree, it was personal why some of the members weren't passing bills for certain vendors and such. So hearing that, I felt that we as a court should update our way of doing things. I know it's been kind of a tradition for District 1.
As District 1 has paid the bills going back to Hoppy Hicks.
So with that change, is there any reason to deny payment of the bills and claims that have been presented to you for today? Hearing none, let the fiscal court clerk record that the bills, claims are to be paid. And that's it for the agenda.
So moved.
Looks like we moved right on time, so is there a second?
Second.
All those in favor say aye.
Aye.
Motion carries.